nothing can take place today in terms of moving this case along, but this is going to be a very interesting meeting of all of these people in the one courtroom. How would you advise your client if you were representing Kit Martin here? Should he say anything? Should he address the court? Should he do anything? Or is it best to keep his mouth shut in a situation like this?
Yeah, I'd keep his mouth shut. I mean, I think he's given way too many interviews. He's talking way too much. This is clearly something they're going to have to take up on appeal. Unfortunately, it sounds like the jury made a decision based on credibility, which is very, very difficult to overturn, as opposed to legal issues or something along those lines. So, yeah, he needs to kind of let the process play itself out. Seems like a nice enough guy. I mean, I can certainly understand why when you have video evidence and you have alibi witnesses and, the motive is questionable at best, in my opinion, that they'd be shocked that they'd come back with a triple guilty verdict for murder.
John, no regrets from Kit Martin there, but let's face it, jurors, when the defendant takes the stand and decides to do that, they're evaluating everything, including the vibe they're getting, right? And a lot of times that can cloud judgment.
I agree 100%. I can tell you in every case I try, every criminal case I try, I tell my client all the time that unless your testimony is critical to your defense, we do not advise taking the witness stand. Every single time I say that, because that's exactly what happens. Because, defendants think that they can talk to a jury and explain their side of the story. But what can happen is, and it's been my experience, what can happen is that once the defendant takes a witness stand, instead of focusing on the lack of the state's evidence or the doubt regarding his guilt, they start fixating on the defendant. Do they like him? Is he arrogant? Does he think he's smarter than them? Does he seem like the type of guy that would commit this crime? And all those factors come into play, which typically do not work out well for the defendant. And that is why in every single case, I tell my clients, do not take the stand unless you absolutely have to. Yeah,
in a self-defense case, something like that, you're going to have to sometimes take the stand. But to your point, they can turn on you for something that has nothing to do with crime alleged. Just your mannerisms can turn a jury off. We're going to step aside, take a break. We'll have more on Kit Martin. We also, of course, are looking at Stanley Ford in Ohio. As soon as they're back on the record, we'll get you back live into the courtroom. Stay with us. But there was no calls to police, nothing done in terms of even going into hiding or creating some sort of security, nothing tangible in terms of evidence that these individuals did, the victims, before their death to prevent their death, yet they supposedly said these words to neighbors. That ruling could have made the difference, Sean, couldn't it, in terms of because that's pretty, as you're a jury, you're hearing this, you're like, oh, wow, they were really scared. The guy's going to kill him.
There's no doubt about that being an extremely damaging ruling. I mean, I think if he has any chance of getting his conviction reversed on appeal, I mean, allowing that hearsay in, I'm not really understanding any exception to the hearsay rule that would allow that statement to come in or those statements to come in. And in my opinion, those are going to be what probably amount to reversible error on appeal, which is his best chance of getting a new trial. And I think, that being the case, Mr. Martin needs to take some other legal advice, which is just shut up. I mean, you just got convicted of triple murder. Why are you giving all these interviews? Why do you feel like you got to state your case over and over again? You tried that in front of a jury. Guess what? It didn't work out too well for you. Stop talking. Let your lawyers do your job. In the event that he does get a new trial, all these statements he makes can be used by prosecutors, in the retrial. So he needs to just chill out, let his lawyers do his job, and hopefully he'll get a good result on appeal.
Yeah, and there's little things that we don't know now that maybe a prosecutor would look back at this interview even that aired with Julie Janae there and say, look, he lied about this little minute detail. Maybe it was about the lie detector, this or that. And boom, now that can come back to haunt you. Bottom line, when people think, oh, well, this jury got it wrong, it'll probably get fixed in the appeals process. That's not how it works. You can't go to the Court of Appeals and say, hey, we'd like a new trial because we think this jury got it wrong. You need something else.
Yeah, there's got to be a legal issue. I mean, the unfortunate reality is, I mean, you cannot get a conviction reversed based on a jury's determination of witness credibility. If you have, 3 witnesses saying he had an alibi with them and 3 witnesses that say something different, well, it's in their province to determine who they believe. And if, for whatever reason, they decide they want to believe the other witnesses, that's not appealable. It's got to be the legal issues, the legal errors made by the judge that are going to be his grounds for a new trial.